So thank you, Virginie, for this introduction. As Virginie told you, I was previously an outside counsel, as we now say, in Paris in the litigation department of Simmons & Simmons. And I wanted to start perhaps with my experience as outside counsel with how companies and organizations dealt with or deal with litigation. And I was surprised when I was in private practice to see that very often, if not mainly, litigation was managed either directly by the business without any support of the legal department, or by someone else from outside, generally the insurance company, which had two positive sides for the company, perhaps. That was the way they could keep litigation out of their sight, because litigation is always perceived negatively in a corporation. It's a mess someone created, and with which you have to clean up, or which you have to deal with, even if you are not responsible for that. And if you are responsible for that, it's even worse, because you are cleaning your own mess. So I was the bad side of this was that as an outside counsel, when talking to the business, you had to explain everything in a very detailed manner because they didn't understand what you were doing, because you were talking a different language. You were talking about procedures they didn't really understood. Or when you were talking with the insurance company, you were talking the same language, but you were often having different interests, distinct interests. The company was always a little bit interested in not covering the loss, and that could hit your client's position, and you were stuck in a contradiction, and you didn't really know who to report this contradiction. So that was my experience as outside counsel. And when I joined Johnson Controls 2 years ago, we just gone through a realignment, but my understanding of the prior organization of the legal department was that we had regional in-house counsels, one in-house counsel in each country, one in-house counsel in each country in each business units. So we had lots of in-house counsels who were dealing with all sorts of matters, but mainly interested in commercial transactions, in negotiating contracts, in reviewing contracts, and having strategic discussions with the business about the business and not about litigation, because that was not why they had joined a company. If they had wanted to be litigators, they would have chosen to go in a private practice. They would not joined as in-house counsels. So that was the former organization, and 3 years ago, Johnson Controls decided to change this organization and to move from a regional organization of the legal department to a more specialist view organization of the legal department, with 4 main specialization: corporate, labor and employment, commercial transactions, and litigation, which is not really original, I guess, nowadays, but which was 3 years ago quite a revolution in Johnson Controls, at least. And the benefit of this realignment was to show how inefficient the previous organization was, because we realized that in the past, each in-house counsel, each manager in the business had its preferred law firm within the same country, across the business units. So each business unit had a different outside counsel, and we ended up with having 15 different law firms in Germany, which was absolutely absolutely disastrous in terms of finance, because there was absolutely no way to leverage the amount of matters we have in Germany, and Germany is our second place for litigation, second most important place for litigation in Europe after France. And if we had all litigations within one firm, we would have been able much earlier to save money, because we would have been able to leverage the amount of fees that, or the amount of matters, to reduce the fees that the outside counsel would have invoiced. So that was the first consequence of the realignment. We demonstrated that the inefficiency of the previous organization by showing that everything was outsourced to different outside counsel without any structure across Europe and within the businesses. So now we are organized, as I said, in what we call centers of excellence. I'm in the Center of Excellence Litigation, and our first task was to select outside counsels in each country. We launched an RFP. We started with our two main places of litigation, France and Germany. First, we decided to have three types of outside counsel: Tier 1, Tier 2, Tier 3. Tier 1 for very big cases, Tier 2 for not so big cases, and Tier 3 for everyday matters, or collection matters, or small cases. We did that in France and in Germany, and after 1 year we launched a second wave of RFPs in the other countries of Europe. We reduced the amount of law firms per country to 2, because we realized that Tier 1, Tier 2 was not really necessary. It was sufficient to have one big law firm for very important cases, and a second law firm for the other matters. And frankly, the main part of our litigations is quite normal commercial litigation without any complicated risks behind an analysis. So any law firm can do it.
Do you want to go through?
No.
That's fine. Okay. One question I had when we previously discussed with Frederic is whether there were different factors that were determining your decision to go from a geographical organization to a much more skill-based organization.
Yes, I think the main point was that in-house are generally reluctant to deal with litigation, and because they are not specialists, they don't like it especially, and moreover, they often involved in the issue. Sometimes they even created the issue by giving a bad piece of advice, by not saying that there was no limitation of liability, and they have to clean their own mess. That was what I was saying before. So having specialists introduced a third party in the litigation, someone from the outside with appetite for litigation, with an experience, because we are all coming from law firms, so we have practical experience from our past lives as outside counsels. We know procedural rules. We know we have reflexes. We know we have reflexes in terms of limitation of time limitation. We have reflexes in terms of who to which law firm to go to, which law firm is the best placed in our panel to deal with one litigation, because we can see the issues at stakes, and we have this experience to determine who would be the best law firm to deal with.
You mentioned also that you are a litigator, as some of us are. What were your real added value internally with your teams and with maybe your subsidiaries, bringing that competence and that knowledge of litigation? Were you able maybe to translate much more? What does it mean to enter into litigation? Were you able to maybe, again, be a translator between what it costs for a company, but what can they gain from it?
Well, the gain is that you are a kind of translator for both sides. The business always seems to understand what the outside counsel is telling them, but in fact they are often missing some technicalities, or they don't understand the jargon, and they don't ask what is exactly meant with a certain term. So we are here to explain to the business what exactly the outside counsel meant, and we are here to explain to the outside counsel what the business is expecting from his advice, and what the internal issues could be. For example, if we have, because as an outside counsel, you have a very external view, or you're very external to the company, so you don't know exactly what is going on. We don't know if you have internal recourses against the factory, or if there are issues. And this is something that you have to know if you want to address them, because if you don't know them, then you will not spontaneously address these issues, and the business will not necessarily think of addressing these issues with the outside counsel. So sometimes the business is talking to the outside counsel, and they elaborate a strategy, and it's the strategy in the end is based on a misunderstanding, and you're here to avoid that kind of misunderstandings, and I think that's the real benefit of the specialist, litigation specialist in the legal department.
Frederic, I have a question. Understanding absolutely from the perspective of cost saving, that makes sense to just have one or two law firms, then agree good deals with them and get a good deal. But my experience has been as an employment counsel. I'm the employment counsel for MEA for Veritas Technologies, and we're talking about 21 different jurisdictions, and it's very specific. And I found that often the law firm we're working with, which might be really good from like a corporate commercial law side, they're not very good on the employment side of things. And then also found some inconsistency that where, for example, one law firm has great lawyers in Germany, but not so great lawyers in Belgium. This is just an example. It might be, you know.
It's a very good example, because we are experiencing the same issue at the moment. So that's a question of the choice between one single law firm across the continent, or different law firms in each country, or different law firms for different specialities. And we had different law firms, for example, for commercial litigation and employment law. That is because we had this issue, especially in France, for example. We were using one firm, very expensive, which was not really adapted to the kind of commercial transactions we had, and which was too expensive for the type of employment matters we had. And a third issue was that it was used as counsel in non-litigation matters, and as counsel in a litigation that derived from their own advice. And this is something the in-house counsel didn't have a problem with, but which was actually a real problem, because the whole argumentation in the litigation was oriented by the advice they gave before, and which was actually wrong, but they couldn't obviously not. They couldn't say we did something wrong, and they had to defend their position, their advice, instead of defending the position of the company. And so I think it's important to have even if you have a specialized law firm for employment law, to have different law firms for non-litigation advice and for litigation, because you can't judge your own work. You can't defend your own work.
What do you have to say with, I think, recent developments would show that there is now a move to globalize. I've seen an instance, without mentioning the client's name, wherein they have appointed a lawyer for all of their branches around the world. In fact, we would have been removed if not for the special service and relationship we've had, and the local company, the local branch, insisted on retaining us. So how do you see this? And what concerns me also, and I would want to hear your comment on this, is that there is now a growing move to do a contract with law firms, that even provide for an arbitration clause, a venue of litigation on this matter. Is this something that has been growing in this part of the world?
So as I just mentioned, we are also in this process of centralizing outside legal service into one firm with different offices across the continent, which and we will be facing this issue of dealing with the differences of quality from one office to the other. And we already know that we are not happy with some offices in some countries, but we are a cost center. We have cost reductions objectives we have to fulfill, and it's a way of achieving this goal. And unfortunately, it's a trend that will be difficult to fight against.
I think what I want to know is it a trend now to stipulate arbitration clauses between companies and the law firms, that in case of a dispute, they will have to go to arbitration, and there's even a seat of arbitration?
You mean between
the lawyer,
the law firm
and
the company? I've not crossed this kind of situation. I think that is a difficulty if you have all your legal matters in one firm to have a dispute with your law firm, because then your whole organization across the continent is impacted by one single issue in one single country.
How do you handle the issue of licenses? Let me explain. In the African continent, for example, it's pretty difficult to say a law firm in Ghana can have an office in Nigeria, have an office in Gambia, Liberia, as the case may be. And possibly you have need for services in those countries. So if you're striving to have a one-stop solution, so to speak, how do you handle an issue like that, where it's clearly difficult for a Nigerian counsel to leave Nigeria and set up shop in Ghana? The closest you can have, for example, is a good friend, a correspondence law firm in those jurisdictions, and that may not meet with the quality requirements that may have pushed you to seek the services of that firm.
I think you have to have exceptions in your contract with your law firm, and we at Johnson Controls, we have always the possibility to go to another law firm if we are not happy with one single office. And in certain cases, if the value of the matter is above $1 million, then we are free to select another law firm. So you have to provide for a certain flexibility in your contract.
You were mentioning that you went through a process internally. Yeah, sorry. Just,
I
just
was-
to go back on the criteria, maybe do you have
I think Mark
precise
wanted
criteria?
to add something.
I was just going to add, because obviously I work at JSI as well, so just so people kind of understand how it's gone, with the Tyco merger with JCI that was mentioned in the introduction to me, Tyco had a single firm tie-up that is being talked about. Frederic and his team did a huge amount of work and came up with these kind of country firms, and obviously as the merger happens, we've got an internal discrepancy of view within the legal department about which is best. But the one company model has huge synergy savings and ease of payment and has value for kind of low value, uncomplicated mass work. But certainly, and with all of my stuff, it's a separate tender process because of isolated, complicated, large matters. So you would always have ability to go outside your core agreement. And it would always be, if you're doing this single source thing, unfortunately for the smaller, more boutique firms, it's always going to be a major player, an Eversheds, a DLA, a firm with huge global footprint. Otherwise, the basic structure doesn't work. So you need that global footprint in the law firm to give you standard approach across the globe.
Yes, I just wanted to give also a reflection. I'm Mikael Wahlgren. I was the former general counsel for Alfa Laval. And we tried both this, having, so to say, individually chosen law firms around the world and having one central one. And I think for coming from Sweden, a small country, dealing with these big Anglo-Saxon law firms especially, that was one problem, and that was, of course, that we had a very good contact point in Sweden, a very senior person, but when we then run into problems in China, for example, he did not have the muscles to influence the Chinese equivalent. You had to find, to say, the right person in the UK organization to be able to push them. And that was really a hassle. I mean, to find that person, I think that is one of the takeaway from me when you deal with these global law firms, that you can't, even if you have a good senior person contact, you still need to understand the structure, who is really the one. You want one contact point in that case, who you can say, do this,
That's
and
the
then he
benefit of
sort
the-
out the whole thing in the world, no matter where it is, and he has the mandate and the authority.
Yeah, so that's the benefit of that kind of organization you have, but you have to have this a strong contact person or the managing partner. And
It's just an advice, because that's experience. So.
Turning now to global companies, no, rather than global law firms. I think one situation on the ground is sometimes the general counsel of the global company, the parent company, which has subsidiaries across several jurisdictions that have its own local counsel, no, internal counsel. The local internal counsel of that global company recommends an external law firm in that local jurisdiction, because that the internal counsel knows very well the law firm or the lawyer. Yet the head, either of the region or the mother company, disagrees with it. How are issues such as this are resolved on the company level, intra-company level?
well, we had that issue when I think you wanted to ask a question about how we
Yeah, it's a
we
criteria
did
of
the
selection of the law
RFP. So when we launched the RFP process, we selected let's say 7 law firms per country, and we of course send the RFP to the law firms we used to work with in the past. So we considered the special relationship one local in-house counsel might have developed with one local outside counsel.
Yes.
And so this preferred relationship went through the RFP process, and we were able to explain why we retained or why we didn't retain this particular law firm based on objective criteria. Of course, once the historical preferred law firm was eliminated of the panel, we had difficulties to put the new law firm in place and to impose the new law firm. But you have to stick to it. You have to sell your RFP to the business, to the finance people. You have to show that it's a benefit, it's a financial benefit. You have to demonstrate an increase in quality. You have to. It's a difficult process. We had difficulties, especially in Germany, where they were very reluctant to use our new preferred law firm, and they were continuously going to the previous law firm, and in the end we managed to cut this relationship by saying no invoice will be paid unless the budget has been approved by the legal department. And so the historical law firm had to submit a budget. If it wasn't approved, it was rejected, then he couldn't get paid. So,
But would that not unnecessarily create a tension between the parent or the region and the local in-house counsel?
yeah.
They soon forget the tension when you save them a fortune, because ultimately it goes back to SG&A. So the minute you show that there is a significant saving, they soon get over the fact that you've made them a little bit more hassle.
Again, you mentioned some objective criteria in your selection process of law firms. Can you give some examples?
Oh,
If you can.
I think they had to show experience in our different business units. So at that time we had 3 business units, building efficiency. So it's mainly construction law, automotive experience. That was specific experience in the automotive area and in the automotive sector, and power solution. That was also a specific experience in the automotive field and with energy and product safety issues mainly. So that was one of the criteria. We had a geographic criterion as well. They shouldn't be too far away from our main places of business. It doesn't make any sense to have a law firm in Paris when your activity is in south of France, or in Germany. It doesn't make any sense to have someone in Munich if your factory is in Hamburg. What other criteria did we have? Basic rates. Of course, money was an important criterion. That is true. That the ability to propose a blended rates, specific rate arrangements. Yes, and the pre-selection was based on reviews, Legal 500, past experience with single law firms, past experience with the company.
Again, you say that now the new organization within your company is that you have a general counsel, then you have a head of litigation, which is you, a head of contracts. And do you have synergies between the two directions? And also, do you share lessons learned from your litigation?
Yes,
and
I think we have two areas where we can have synergies. One is the management of pre-litigation. It's something which is usually managed by the commercial lawyer, so the lawyer in charge of the negotiations of the contracts and reviewing the contracts. And when there is an issue, this lawyer will be the first point of contact for the business, because he knows the project, he knows the contract very well, and he's able to give a first advice. And at some point, when he sees that things will not go right, then we would be involved, and we will give our view on a possible litigation strategy. Does it make sense to go to litigation? Do we have good cards in our hand? Is it should we force a settlement agreement, or should we let it go to litigation? So that's the first area of synergy. And the second one is what you said, what you mentioned, lessons learned. When we finish the litigation, when the final decision is rendered, then we have a meeting with the commercial transactions team, and we discuss what went wrong in the matter, why we lost, also what we did right, what they should have done. That kind. I was thinking of an example. We had in the past in our automotive business unit, we had parts manufactured in Turkey that should be shipped to America, and for the shipment we bought some pallets from a Turkish provider. The pallets were marked as being treated against parasites, and when it arrived in the US, the customs noticed that there were parasites in the pallets. They rejected the goods, and we didn't keep the pallets. We destroyed the pallets, and we were not able to demonstrate to the provider, to the pallet provider, that the pallets had not been treated. And we had photographs, we had reports from the American customs authorities, but the pallets were not there anymore. So we had a very bad case because we couldn't demonstrate that they did something wrong.
Especially when it comes to disclosure obligations, it is a nightmare sometimes to be able to get all the emails above the table that have been sent from various branches all over the world. And I've been liaising with one bank on that over the years, how to manage that, to implement a protocol that everyone who leaves the job transfers all the emails to his boss or something. Have you managed to implement something like that within Johnson?
We haven't managed.
No.
We have identified the issue, and we are struggling to find a solution to how to keep records of everything, and especially in our environment at Johnson Controls, where we are merging, selling businesses twice a year, and people go and with them all the knowledge is gone, and sometimes documents are lost, and it's a very big problem for us.
I noticed that in these cross-border cases with branches in various countries, sometimes you just settle because you don't know what's in the file, basically. And the fear of being caught out of having hidden something during the proceedings while you weren't aware that you were hiding it, and the disclosure obligations are getting bigger and bigger, at least in England and the Netherlands. And but I think it's an unsolvable problem.
We have a nice case in the UK where we are being accused of not having done maintenance services properly, and the problems date back to 2002, and we have absolutely no record of what we did, what we didn't, if we subcontracted these services, and
Keeps the job interesting.
yes, exactly. In a way. Until you have to report to the manager that his case is not going to to go very far.
Then he lost, not you. That's it.
Yeah, basically, yes.
Quite helpful is to have, like, record management policies, clearly email retention policies and retention schedules that just clarify for each department how they have to go about the documents and the emails, how long they have to keep them depending on the jurisdictions. And so that's definitely helpful, but then to do that in practice is then another challenge, of course.
The problem we have though is kind of in a big corporation like JSI, we've got what is it, 60,000 employees, if not more. In
117,000.
well, there were even more than. So you got 170,000. You don't know, kind of, the arbitrations or the litigation is 3 years after the event happened. So you don't know who to tell to keep the records. I mean, once the litigation starts, then you can put kind of retainers on and make sure people get fired or leave, you can retain it. But when you've got a huge corporation, I think you're right. It's a situation you can't solve it because we don't have the server capacity to keep every single email on a central server. So you're relying on individual employees to use PTS files if they're using Outlook. We had an issue where we actually migrated from Lotus Notes to Microsoft Outlook. And that was right in the middle of the arbitrations that I was talking about earlier, and that lost all kinds of data because the company policy was it was left to individuals to back up their emails. So, I mean, it is I think it's an issue that exists and will always exist, and I don't think there is a solution at all because the records are just too many.
Yes, there is a question there.
In Johnson Controls, when you receive notification of a new litigation or like the prospect of new litigation, do you send a document preservation notice out to your employees or rely on your employees to preserve their documents? Or instead, do you take an electronic image yourself through the IT department so that the corporation, the company, is certain that it has an actual image, electronic image of those files? And do you have any views on which is a better practice?
Actually, I would ask the business to preserve any kind of evidence and to send it to me so I can have a good view of what is available or not. And but I don't think I have the possibility to ask the IT department to freeze or to take a photograph of the actual situation, current situation. I don't know if in your arbitration, which is perhaps more relevant.
We have an investigations team that has the ability to track centrally and record centrally emails and files and whatever else. But in direct answer to your question, as a matter of course, it doesn't go out. To be fair to Frederic and his team, he's got 3 people for Europe. There's 5 people in America and 1 in Asia, and then me and 1 other that kind of have this roaming role. So we can't be in control of document retention. It's kind of, we can only tell the business to keep it and go through. But we have limited ways that we can centrally kind of put checks to make sure emails aren't deleted and things. But back to my earlier point, that it's normally after the event. So kind of it stops people deleting it, going back in, but it doesn't stop it from having been deleted in the past.
And how far then does Johnson Controls take the document preservation notice? Do you require the recipient of those notices to respond and acknowledge that they have received the notification, they are taking steps to preserve relevant documents?
I mean, the fact that we're kind of giving 2 different answers shows that it's not a universal thing. But for me, when it was involved in this NDIA, the big airport stuff, it was an individual-driven process where I made sure that they came back and everything was recorded because we knew we needed the files and we needed people's C drives. And because it was a construction project where everything was worked off of individual C drives as opposed to a central server, it was even more important. Whereas on other matters where it's kind of recorded in the central system, it was, in my opinion, far less needed. So I don't follow it up on an every basis. I don't know if you have an individual policy for other stuff.
No, it's quite no, not very developed.
I'm not much of an IT expert, but we had one solution in a transaction whereby you could feel along the way, and I was sitting in-house at the bank then, you could feel along the way that this would end into a dispute. And then from that moment on, we opened a special mailbox in which everybody within internally had to, well, copy that mail address in, and that restored a lot of emails, and also external emails had to be copied with that, and that was a very easy solution, just one mailbox having it all. Then still you don't know if everybody really copies you in, but it worked.
That's a good idea.
Basically.
Thanks.
Just a general question in regards, because excessive data flying around because, we need to know where they are and we need to be able to track them and delete them at certain requests. And on the other hand, we have this situation that if we face litigation, that we may not have the documents and email in store that we need. So how do you, would you say, where do you see the balance? Or how do you have like a retention time period scheduled for your, how long you're keeping emails?
I'm actually not aware of any retention policy within Johnson Controls. I don't know if you are aware of this policy.
Not for individual emails. Every using email is the main example. We have obviously retention policies
For documents, yes.
With dealing emails is the big issue because you don't know. I would just have one comment that sometimes I'm quite happy that we can't find emails. So even when we instruct kind of the companies that go in and do the forensic searches and whatever else, I've had matters where I know that somebody would have sent an email which I'm dreading when it gets disclosed and it never gets found. So there are also benefits to it as well. You've got to be careful what you wish for.
Fair enough.
We can easily track contracts and official documents, but as you said, emails and correspondence is not really impacted by any retention policy. So.
Maybe I have a return of experience for you. It's a e-discovery on a big international corruption case in a special sector of the industry where the client is particular and very specific in preserving his IT and his data. And they did have, and they still have internally, a big IT department, very good. They used to have hackers that they hired. So they have a total control over all the exchange of emails, and especially they have a compliance department, so they control everything. And we had also have to, for this discovery, we had to buy a software, which is called Tower, and it's developed by a UK-based company. And so you define keywords with your law firms and with the client, and they keep searching and searching, depending of the custodians, depending of the keywords, depending of what you are looking for. And it's a process, it takes like sometimes years. So you have to really go through and select keywords and assess them and always constantly assess the situation and which keyword is the best. And we can have a lot of information. It's easier when you have at the top of the pyramid, and especially for like directors, CEOs, CFOs, because they have to keep track of everything. And actually we already had like handwritten notes. We got a lot of things and things that are quite surprising. So my advice is like there is ways, and sometimes you also go to intelligence agencies where they can, it's whether legit or not, but it's always a bit shady, but they do have a lot of information to provide. So yes, there are ways depending of, but it costs a lot. I mean, like the budget for this e-discovery, it's just like, I think the budget monthly, it's $500,000. So in terms of forensic lawyers, the TAR, so yeah. You're welcome. And also, I wanted to go back to one comment you made this morning regarding in-house counsels and the difficulty they do have to have a precise recommendation from law firms. And I wonder whether it's easier for you maybe to translate a legal advice that is not so precise for the internally, or if you push your lawyers maybe to be more specific, to do some risk assessment and to really measure the risk, even though we know that it's the client who has to make the decision.
I can use my experience, my past experience as outside counsel to push the law firm to give that piece of advice I want, in the form I want. I don't want them to give me the answer I am expecting. I'm just asking them to give me their expertise and the answer to my question, and not a global comment on the situation, which I could have made myself with my background and my knowledge of my legal knowledge. I want the expert's opinion on my issue, and sometimes it's difficult. Recently, I had an employment matter where I was asking the outside counsel for an analysis of the case, and I wanted to have their opinion on our chances to win or to lose. It is always the same. And I got 3 emails with no answer about this. And finally I said, do you recommend to settle this case or not? And I got the answer this morning. I haven't read it. I hope I've got the right answer in terms of of expectations, but 3 emails.
Knowing what you probably know about the facts of the matter, and nonetheless insisting that you want a specific answer as to whether or not you win or lose. And you know external counsel is to some degree hedging, but ultimately is pushed to answer either in the positive or negative. Does that affect the paycheck at the end of the day?
Sorry, that affect what?
If the decision goes contrary, despite the analysis of outside counsel, knowing what you know about the facts of the matter and knowing that you actually pushed for that answer, you got the answer, possibly an attempt by external counsel wanting to sell his skill set and business to you, but it turns out the decision doesn't favor you. Does that affect the paycheck? You stop paying him.
All invoices are cancelled if they lose.
Yeah. Because
no.
Yeah. The argument is
if I push someone, as I said, I don't push our outside counsel in the answer I want. I push them to give me an answer based on their expertise. And if it's not what I think or what I expect, well, I have to rely on their expertise. But if I do not agree with them and I force them to agree with me, and it turns out that I was wrong, then it's my responsibility, and I will not accuse the outside counsel for giving me the answer I wanted. And it doesn't affect
the bottom line.
No.
There's also a bigger issue that if you get opinion from an outside counsel, you can persuade them to change. You know that their opinion isn't really working.
Yeah, I agree that, there's some argument that can be made in favor of that point. But, we live in an increasingly business-minded environment. And there's a practice of law and a business of law. And sometimes some law firms are structured in such a way that counsel sometimes find themselves in a conundrum. They don't want to use the word offend, I don't know, but they just want to be careful to keep that business coming through. So it may sometimes be a difficulty on their part to stick to their position. I wouldn't do that, of course, but I have to make that quite clear. And regardless of how offensive it might be, I've always taken the view that it's best to let the client know where they stand, and you sink or swim with them. Some clients do what you call the deep dive after the first assessment, and as the matter, particularly for litigation cases, as it progresses, maybe beyond the preliminary stages and before trial, they can do a deep dive on the matter to see if there are issues that could alter originally held positions. So I have clients who tell me that we sink or rise together. So the decisions you make are not strictly speaking yours, which even calls the question whether to some degree external counsel ultimately has total control, because increasingly you have in-house counsel take up positions that, after rigorous argument, aligns with that of outside counsel, simply because they want to see what you're doing on a step-by-step case. So you both rise and fall together.
But I think you, as an in-house counsel, you are the one who takes the decision, and it's backed by an outside counsel. But it's still your decision. You will defend it in front of the managers. If it's wrong, it's your responsibility, and you can blame the outside counsel. But you're paid for your own expertise, and you should have you should have raised the hand if you were not satisfied with the outside counsel's advice, or if you had any concern.
Is there any other questions? Yeah.
Well, I'll just add a point on that topic as well, also serving as in-house counsel. I mean, there are instances when we have legal challenges, and perhaps as in-house counsel, we've identified what we believe the best solution or path forward is, but we don't know legally what's the path to get to the outcome that we're hoping that we can get to. And in those situations, we do approach outside counsel to address these very challenging issues and give us recommendations on how we can accomplish the result that we're looking for. Now, there are, of course, instances when outside counsel may say, we hear what you're looking to do, and it's not legally possible, and that's fine. But we do expect, outside legal counsel to think sometimes outside the box, think creatively, and develop those legal solutions. And that's really where you provide a lot of value to us as in-house legal departments as well.
Is there, from your experience, a line between providing legal solutions and actually taking business decisions for the client?
Yeah. We don't have any expectation that you're going to take business decisions for the client. And in fact, as in-house counsel, we also don't like to take business decisions for our internal business clients. But instead, we're looking for those legal solutions. And so unless your client asks for some business advice, and I would caution you against providing that,
I agree.
Really, I would stick to the legal advice.
So
Yeah.
I agree. Thank you. I'm sorry, it almost became a... Sorry.
Yeah, I agree. I think we both agree. We both been lawyers and litigators, and I'm still a litigator, by the way. Sometimes I think there is this tendency, maybe among us, that we can't really provide clear-cut recommendation, depending if it's a new client or not, and depending also of the policy within your law firm. I think maybe it's a prejudice we have that in-house counsels or business partners don't like to hear no. So we tend to say yes, but instead of saying no. But again, I think, and as you said, and we share previous experiences, I think it depends also of the trust you have with your law firms and how far you push them and how precise you are of what you are expecting. And maybe sometimes say, okay, thank you for the recommendation, but clearly here we are at a turning point, and we really would like to have much more recommendation. It doesn't mean that you're going to take the decision, and we're clear about that. And it doesn't mean that if the scenarios you provide to us do not align with our objectives, we're going to get rid of you anyway. But still, I still want to have more recommendation, more scenarios, because if this objective I can't reach out through the process I have already designed, which other process may you suggest for me? I know it's a bit like you have the impression that sometimes not your role to play, but sometimes just to say that through an email or phone call can really push the associate or the managing partner in front of you, to feel more at ease with you and say, okay, he's ready to work, and even if I say no, he's ready to hear that, and then we can collaborate and cooperate. So that's the way I will address it. And because you are the client, maybe you have much like leverage to say that, than sometimes internally, depending again of the litigation policy within your law firm. You are not, if you are a senior associate or just an associate working on the case, you maybe not have as much leverage as the clients do, so just use it. And that will be my recommendation. Yeah.